and you did it again. It just makes me look like an idiot. You said you were with the wrong person. I'm going to tell you like I tell everybody else. You are the wrong person. Of a new theft of property from July 31st of 2025 here.
Right away, this judge is coming in heated. That opening line, "you did it again," tells us this isn't a first offense. We're looking at a repeat pattern, and in court, repeat behavior destroys credibility fast. So ask yourself, when a judge already sounds frustrated at second 0, how much patience do you think is left?
In Jefferson County.
He's got a plan. Come up here. Hey, you're being detained, okay? Okay, we'll worry about that in a second. Just come over here so we can talk. Okay, so you're not under arrest, you're just detained. And so, I thought she was detained right now.
She just took everything out and dumped it on the floor back there. Just hand back.
Is it illegal? What we're doing, look, if you have anything illegal, look at me. Hey, just look at me. If you have anything that you didn't buy, just send it on the counter.
Can you take $2,000?
Not at the moment, no, because
The way you're acting, you're acting like a fool.
Oh, no, I'm not gonna do this. I promise I'm not.
just like I said, just put it on right here. Nothing else in your pants or anything?
No.
All right, let me.
All right, any other evidence with regard to count 1?
There is also the footage from the inside of the car where both are detained, where she actually speaks to the other defendant without the cops being there, and she talks about how she was here and you had told her not to do this anymore. But I think that first video kind of sums everything up.
All right, any evidence with regard to count 1 before I make my finding?
Evidence, Your Honor, in testimony.
And anything that could,
I'm looking at this trying to figure out if that's a legal search. I mean, she appears to be detained.
Now this is where it gets legally interesting. Warrantless search territory. The judge is actively questioning whether this was a lawful search or a violation of rights. But here's the twist. If someone voluntarily hands over evidence, it can bypass a lot of those protections. So the big question, was this compliance or subtle coercion?
So it's not a Terry search. It's a warrantless search, obviously. She's not under arrest and being searched at the jail.
they didn't search her. They said, if you have something, take it out. She took it out and she placed it on. They didn't even have to get to the search.
I guess she could have refused and remained silent.
But she didn't, and so.
Followed the direction. But there's
Yeah.
no Miranda issue since she wasn't
Right.
arguably in custody. I don't have any argument. I will go ahead and object that that's an illegal search.
All right, that objection's overruled.
And just like that, objection overruled and count 1 is found true. That's a decisive moment. The judge is essentially saying, I've heard enough. In legal terms, that means the evidence crossed the threshold. But from a strategy perspective, did the defense push hard enough here?
I am going to find count 1 true. And so, let me see, I need to. Counts 2 and 3, she pled true to, so there's a finding of true, count 2. Again, everyone's had an opportunity to review that pre-sentence report. Mr. Kemmler, you may make argument with regard to
Yes, Your Honor. At this stage now that the state has offered evidence as to count, as to be a new offense, and the court's found that to be true based on the evidence, I think that the recommendation comports with the state of the record. I would, again, defer to the probation department, but I think that they're seeming to indicate that the court is to keep her on probation, that she enter into the ISF program, cognitive track, and I would defer to that recommendation in lieu of revocation.
Mr.
A proposal, I suppose,
With the pending charge of this theft, she's not eligible to go to ISF.
she's, if I may, she's set on that today. I can resolve that today in this.
No, it's pending in felony.
It's here, it's mine.
Okay.
Because it's a prior thefts.
All right.
She's done with misdemeanor
Right.
thefts.
We could resolve that perhaps today, Your Honor. Or
I mean, I'm, go ahead. What was-
State, I feel like we have given her every possible chance to rehabilitate, and she has not taken that. We would
Listen to the prosecution's tone. They're done negotiating. When they say every possible chance, that signals a history of leniency that didn't work. And once the court starts thinking rehabilitation has failed, sentencing usually gets a lot harsher. So now the stakes shift. This isn't about fixing behavior anymore. It's about consequences.
ask that she be revoked and given, based on the number of thefts committed, that she be revoked and sent to the state jail for 2 years.
Ms. Lopez, do you have anything else to add to your updated
I'll put
report?
everything in my recommendation.
All right.
do you want to address the judge?
Yes. I feel like I did, how can I say this? I feel like I can finish my probation off because of the simple fact, like, this is the longest I've ever been away from my kids besides when I did 8 months, but they was younger than me, and like I was younger, and like they understand what's going on. And I understand, and like me being away from my kids right now is really hard. Because they live with my mama, and my mama had dementia. And she...
Stop with everybody else. Because I'm not going to make my decision today based on the fact that you have kids or based on the fact that your mom needs you, because you weren't thinking about that day. So don't put that on me.
No.
That if I send you to prison, that I'm somehow going to be hurting your kids or hurting your mom. You've done that. You were on felony probation, and it sounds like if the other video was played, you knew exactly what was going to happen. If what Mr. Smith is saying is true, that y'all were in that car and you said, Judge West said, I better not do this again, and you did it again. It just makes me look like an idiot for giving you the opportunity in the first place. At some point, you have to stop.
This is the emotional pivot, and the judge shuts it down immediately. Bringing up kids and family can sometimes influence sentencing, but not when the court believes you ignored those responsibilities during the crime. That line, "Don't put that on me," is powerful. It reframes the entire situation. Accountability stays with the defendant.
At some point, you have to stop. Anything else?
Judge, even based on what she told probation is, she wants to be reinstated on probation. She was just with the wrong person. The girl she was with already took probation.
Right.
I wasn't the one stealing.
Yeah,
So she
I made a
doesn't
note of that.
Accept responsibility.
How is this my responsibility?
You accept your responsibility now that we saw it on a video. You didn't accept your responsibility. You said you were with the wrong person. I'm gonna tell you like I tell everybody else. You are the wrong person. She was with the wrong person. Y'all were with the wrong, you're all, if you're in there doing it, you are the wrong person, right?
Yes, ma'am.
So you didn't take responsibility. You haven't taken responsibility. You were given this opportunity after having felonies and going to state jail for the same offense, and I gave you a probation, and I said, don't do it again. So at this time, I'm going to find again count one, that there was sufficient evidence to find count one true, find it true, find that you pled true to counts 2 and 3, find sufficient evidence to revoke your probation, and at this time, revoke your probation, sentence you to a term of 15.
And there it is, the final hammer. Probation revoked, 15 months state jail. Notice how the judge ties it all together. Repeat offenses, lack of responsibility, and prior leniency. That's the full checklist for revocation. End of the road. No more chances. So what do you think? Was this sentence fair? Or should the court have given one last opportunity?
Months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to
I'll get the other one
Okay, I'll hold it while y'all do that, and then while I'm doing that, I need a, yeah, I'll hand you the trial court certification in just a minute after y'all do that on this case that shows this was not an agreement. You have some limited rights to appeal. If y'all want to go visit about the other one, I'll hold it. All right, go ahead, go back that way. And then you've got Dylan Wilkinson.
Yes, Your Honor. On that one, I'm not sure if y'all got it. I did it over the weekend. I have filed a motion to amend bond conditions. I printed it out just in case. And Mr. Nichols has a copy.
That's my case, Judge, and I did review it this morning. So we can proceed.
Let me see if I've got it. I kind of doubt it, but you never know.
I don't know if they've accepted it yet.
It's here.
You got it?
Yep. All right, sir, are you Dylan Wilkinson? Yes, ma'am. And this is 25 DCCR 0260, and Mr. Wilkinson is charged with deadly conduct, discharging a firearm. Ms. Holmes has filed a motion asking for me to amend the bond conditions.
The GPS bond. And in addition to the monitor, the bondsman and the GPS company also have his phone location. So he shares his location because there was an issue where they thought he had cut his monitor, so they FaceTimed him to show that it was still on his leg because it wasn't showing in their system. So in addition to it on his leg, he also shares his location with 3 other people from the company on his phone. And so because he travels a lot, it's causing issues with the job. He's a traveling technician. He's currently in Utah.
Let me look at something real quick. Mr. So I got that information about the job and I approved, as long as bondsman, he keeps them up to date. And Mr. Nichols, what's your position?
I don't really have an objection to modifying that condition, Your Honor, as long as there's a way for the bondsman to locate and contact him at all times. I have no indication there's been any issues since the inception of this case. I don't think they're to contact. It was a dating relationship issue. My understanding is they don't have any contact anymore. There has not been any issue. As long as that continues, I don't have a problem with that.
Did I or anyone make a condition of your bond that you're not allowed to have any firearms?
No.
Okay, so as of today, that's a condition of your bond, all right? So you cannot be in possession of any firearms. If you're in a car, someone else can't have one in the car. You can't be anywhere around any firearms. That's now a condition of your bond. Yes. So as long as you continue to share your location with your bondsman, then I will grant that motion, amend the bond condition for you to remove the GPS monitoring device. You know you're definitely not supposed to have any contact or communication with the complaining witness, correct? Okay, so just continue doing what you're doing, work, go home, don't contact her, don't be in possession of any firearms, stay in touch with your bondsman, do everything they're supposed to, including sharing your location, okay? And then do we need to just reset it for an announcement,
yes,
or are y'all ready to announce?
Can we have one more reset, and if possible, could we extend it a little further than normal due to him having to make arrangements to come in?
So what I'll do, Mr. Wilkinson, I'll make it a little bit longer, but we'll need to have something taken care of at that next court date. Either it's going to get worked out with the plea or it'll get moved to the trial docket. So this will be the last announcement hearing. So make sure you get in touch with Ms. Holmes, have a conversation with her before that next court date so you know what your options are, and then we'll figure that out the next court date. So I'll do about 45 days.
Okay.
Okay?
Yes, sir.
You can go with, you're free to go, sir.
And then,
Started to say,
I know, I almost said it.
hear that. Especially when he said he had a flight at 8. I almost said, yeah, you can make it.
I know. Yep, I almost said